a couple of things with respect to workers' comp. Following up on what Seth was talking about with respect to independent contractor. Obviously, we're seeing this a lot, as Seth mentioned, with respect to the Department of Labor issues. It's all about control, the method and means of control, and related to that is the number of hours, whether or not the worker has set hours with respect to that particular job. So if they have set hours, for example, they have to work, a morning shift or an afternoon shift, then the likelihood is that they will be considered an employee and not an independent contractor. If they have the right to take other positions, other jobs, other assignments besides the work that they're doing for this particular company, then they would be considered an independent contractor. But we often see that employee or workers don't have the right to take other assignments. They're dedicated exclusively to this particular company, especially because, again, with the set hours, the company wants them to work a particular period of time because that's when the customers are home, et cetera, then the likelihood is that they would be employees. This is a big problem in the trucking industry that we're seeing now. UPS was just hit by the Department of Labor for a multi-million-dollar judgment because of their misclassification of employees. There seems to be this notion in the trucking industry in particular that just because they have these workers sign these independent contractor agreements, or any industry, that somehow they are exempted from that requirement that these workers are considered employees. That's absolutely not the case, and I've seen this in workers' comp where companies will call me, they have this agreement that identifies this worker as an independent contractor. It's meaningless if these criteria under the law, like control, like the right to take other assignments, et cetera, are met. They will be considered employees. So again, we're seeing this. We saw this. Uber was just hit with a big judgment against them that they're appealing. Home health care staffing agencies, same type of thing over and over. It needs to be on your radar if you use independent contractors. Let me just shift gears a minute. One other topic that I wanted to talk about, because it's a huge misconception, probably the #1 misconception among companies with respect to workers' comp, and that involves post-accident drug testing. There seems to be this belief out there in the working world that if a employee tests positive post-accident for alcohol or drugs, then the claim will be denied, they won't be entitled to temporary total disability or lost wages, and the whole thing goes away. It's absolutely not the case. Employers, let me just set up the scenario for you so you understand what's going on. Company has a policy, as the vast majority of companies do, that require post-accident drug testing. There's an injury, and because of that injury, employee gets treated at the hospital, and there's also a requirement for a post-accident drug test. Employee tests positive, and also they are disabled because of the injury. So the company terms that employee because of the positive post-accident drug test. And they think that's it, it's over with. That is not the law. The law says that regardless of the fact that you have a post-accident drug testing policy and that employee tests positive pursuant to that policy, unless the company has reasonable suspicion that that employee was impaired at the time the injury occurred, impaired because of their drug or alcohol, then that claim will be allowed. And there's a safe harbor I'll get to in a minute, but that claim will be recognized under workers' comp law, and temporary total disability will be paid under the law. It's almost impossible to meet that reasonable suspicion standard. I think I've seen it maybe 1 or 2 times in my experience. And the reasonable suspicion examples would be glassy eyes, altered gait, you know, has history of excessive tardiness, et cetera, et cetera. Most of the time, you won't see that because co-employees do not want to rat out the employee and say that, yeah, we saw that he seemed to be a little off, something was unusual, he seemed to be impaired. So that's the number 1 problem. It's just not apparent, or employees who observe this are not willing to come forward when you interview them afterwards and ask them, did you see any sign that this person was under the influence of a drug or alcohol? In addition to the fact the whole policy under workers' comp law is ridiculous, in my opinion, because obviously if someone is impaired and you're aware of that at the time, you're going to intervene, most likely, to prevent an accident. So again, this reasonable suspicion requirement under the law that permits you to knock out the workers' comp claim if the person tests positive post-accident is hardly ever met. So what happens if you can't meet that reasonable suspicion test, and now you've got this claim that's going to go through? The only exception under the law is you have to get medical evidence from a physician that based on that level of testing, the employee was impaired at the time of the accident and that impairment caused the injury. And that also is very difficult to get, typically because if it's let's say a positive marijuana test, we see this a lot where the employee claims that they were at a party over the weekend and they inhaled it, or maybe they smoked it themselves, but now it's they worked Monday, it's Tuesday, they had the injury, they tested positive because marijuana, more than any other drug, stays in the system for a while. They tested positive post-accident, and maybe it's just above the cutoff. Then it's very difficult to get a doctor to say, yeah, they worked Monday and they were fine. All of a sudden Tuesday, because they had an accident and they tested positive post-accident, that they were impaired and that impairment caused the injury. So it is difficult to get that. I'll just digress in a minute. I have a case now where it's a very tragic, sad situation. A roofer who fell through a hole in the roof and ended up dying 3 days later. At the hospital, the 3rd day, he was tested, his blood was tested for any drugs, and he tested off the charts for marijuana. So in that case, we were able to get a report from a physician that said, especially or precisely because of the exceptionally high level of marijuana that he tested for, that this physician was able to say that this person tested, because this positive post-accident test was because of this impairment, because of the high level of the marijuana consumption or ingestion, and that caused the injury, and we prevail at the hearing. But that is the only situation where if there is a positive post-accident drug test, and again, you don't have that reasonable suspicion, that you may have an out with a report from a physician. That's all I have.